In the previous lesson, we looked at the concept of the offer when we are examining whether or not a contract exists, looking at the creation of contracts. And we made a point at the beginning of the last lesson focusing on this idea of making a delineation between what a genuine offer can be, and therefore where legal obligations may arise, versus simply an invitation to treat, which is not an offer, but may look like an offer in certain circumstances. Well, we're going to look at this in more detail in this lesson. We're going to look at some of the cases that have essentially weighed in on whether or not there was an offer in question or whether or not there was an invitation to treat. And we'll talk about the circumstances by which we find offers versus invitations to treat in this lesson and the next lesson. So, like I said, the reason why this distinction is so important is, of course, because when you have an offer, and if a court identifies that an offer exists, and then there is the potential for legally binding implications, whereas there are not those same legally binding implications with just an invitation to treat. So we have to make a delineation in this regard. The first question, therefore, is what is an invitation to treat? What do we mean when we talk about this particular concept? Well, an invitation to treat is simply an indication on the part of one of the parties which suggests that they may be interested in negotiations, and that the negotiations may ultimately lead to an offer being made. So it's almost like, in certain circumstances, the step before the formal issuance of an offer. So it is almost like the formal process that exists before any potential legally binding implications can actually be ascribed. Comparing this to an offer, which displays a clear intention to be legally bound by the terms and by the agreement that is in question, an invitation to treat is not that. Now, there are many instances where the court has tried to make a distinction between these two concepts. The reason why, as I've said before, is because with an offer, there is legally binding implications. There is this idea that, well, you then have to perform the contract or be in breach of contract. Whereas those same obligations are not there with an invitation to treat. Similarly, there may be potential consequences if you can identify an offer within a particular transaction rather than just simply an invitation to treat. And this is in relation to the statutory interpretation of certain offences, for example. We'll get to that as well, where there is maybe the selling of or the offering for sale of potentially banned substances or banned items, and the courts have to ask the question of whether or not there actually was an offer there, and therefore potential criminal liability, or whether or not there was just simply an invitation to treat, and therefore no criminal liability. But we're going to begin with another case against the Manchester City Council from 1974, and this is the case of Gibson and Manchester City Council. We have this case which essentially involves the Manchester City Council, who were in the process of selling a number of council houses to their tenants. And the claimant, Gibson, made an application for details which pertain to the purchase, where the defendant replied, making the claim that they may be prepared to sell at a fixed price. That is essentially the back and forth transaction, the back and forth conversation that was had between Gibson and Manchester City Council. They also made it clear that the claimant would have to make a formal application as well. So they, quote, may be prepared to sell, and the claimant would have to make a formal application in relation to the sale. Now, after a series of local elections which took place in 1973, I believe, or 1974, a new political party came into power. The new party was the Labour Party, and they then made the decision to discontinue this policy. So they came into power and they discontinued the policy of selling council houses. So if we look at the timeline, you have one political party in power that say that they may be prepared to sell at a fixed price, owing to this policy that the Manchester City Council had of selling a number of council houses to their tenants. After a series of local elections, this policy was discontinued, and they made the decision to stop this policy of selling council houses to their tenants. The claimant, in this case, would then sue for breach of contract. So the question for the courts is whether or not the application for the details pertaining to the purchase and the conversation that was had between the claimant and the defendants constituted a formal offer and an acceptance of the offer, and therefore a legally binding obligation, such that the decision to discontinue this policy would be a breach of a contract. It was held that there was no offer made in the letter, and therefore there was no contract, and therefore there could not be any breach of contract. The words "may be prepared to sell" did not display the contractual intent that they were going to and be prepared to sell. It says here they may be prepared to sell. There was a potential that they could have been prepared to sell, and that the claimant would have to make a formal offer. I see no reason in the instant case for departing from the conventional approach of looking at the handful of documents relied upon as constituting the contract sued upon and seeing whether upon their true construction there is to be found in them a contractual offer by the corporation to sell the house to Mr. Gibson, and an acceptance of that offer made by Mr. Gibson. A far more landmark case in this particular vein comes from Pharmaceutical Society of Great Britain and Boots Cash Chemists from 1953. This is a very famous case, and this case hinges on the question that I noted in earlier on, this question of whether or not, if there was an offer and if there was a formal contract in place, then that could give rise to certain liabilities under statutory provisions, according to particular pieces of legislation. And so this is a case that hinges on that question. It examined the question of whether or not the display of goods in a shop window would constitute an offer, or whether or not the display of goods would actually constitute an invitation to treat. Now, more specifically, not within a shop window. I should make that very clear. Actually, it is actually more specifically displaying goods on a shelf in Boots Cash Chemists, which we will get to. Okay, the shop window example is a different case, which is also very famous, which we're going to look at in the next lesson. So we have the defendants, Boots, who had a policy which essentially allowed individuals to walk into their chemists, pick the drugs off the shelves in their shops, and purchase them at the till. As you might find in any ordinary shop, you have the potential drugs on the shelves, and you can go and pick them. Now, the issue with this was that the Pharmaceutical Society of Great Britain argued that this was actually in contravention of a particular piece of legislation, specifically the Pharmacy and Poisons Act of 1933, in that it represented an offer. They were trying to make the argument that the displaying of the drugs, the items on the shelves in the shops, represented an offer, and then the action of the individuals grabbing those items and putting them into a basket represented the acceptance of that offer, and therefore a contract was formed through that particular process. Now, they argued that what this did was violate the Pharmacy and Poisons Act of 1933, because the Pharmacy and Poisons Act specified that the sale of drugs required the supervision of a pharmacist. So if the offer existed, if that was an offer by displaying them on the shelves, and that the grabbing of the item and putting it into the shopping basket represented the acceptance of an offer, then that would represent the sale of drugs. And because this was done on the shop floor, it would represent the sale of drugs without the supervision of a pharmacist, therefore a violation of the 1933 Pharmacy and Poisons Act. It was held, however, that the act of displaying the goods on the shelf was not an offer. It was instead an invitation to treat, because the contractual arrangement is only formed when the individual goes to the till and purchases the item, at which point a pharmacist will be present, because they will be the ones who do the transaction at the till, and therefore there is no violation of the law. And so the idea that the display of goods is an offer, and that putting those goods into a basket is an acceptance of that offer, would actually be absurd if we think about it and we looked at how this is applied. Because what this would essentially suggest is, therefore, that every time I go into Tesco or I go into Sainsbury's, I can go up to a shelf and I can take an item and put it in my basket. At that point, I am now legally obliged to go and purchase the item because that represented an offer and an acceptance of an offer, therefore representing a legally binding agreement. What if then I change my mind and I want to put this item back and get a different item? Do I have to first pay for the item and then therefore go back and change my mind? It doesn't make sense to suggest that an offer is represented as the taking of the item from the shelf. Now, this position is not without its criticisms. Okay, it makes sense to suggest that it is not in and of itself an offer, and that the putting it in the basket is an acceptance of an offer. That doesn't make sense. But are there other ways in which we can think about it? What could it be the case that putting the items in the basket isn't the acceptance, but that the display of goods could still be the offer? Could it be the case, for example, that the display of the goods is the offer to contract, and that the acceptance is represented by the purchase of the items at the till? So the offer is done to the customer by displaying the goods, and then they put it in the basket. Nothing happens by putting the item in the basket, but when they go to the till to purchase the items, that represents the acceptance, and therefore the contract is formed. That would therefore mean that we can have a situation where we can take items off the shelf and then not be legally bound to purchase those items, but it would also mean that the case of the Pharmaceutical Society of Great Britain actually did represent an offer and would therefore have represented a violation of the Poisons Act. This is actually a case approach which is taken in the US, specifically within Massachusetts, of Lasky and the Economy grocery stores from 1946, according to Murray 2023. So this is not an unprecedented approach. It's an approach that has been adopted by other states, other common law jurisdictions, and one that does merit something of a debate that could be had. Welcome back, everybody, to the Law of Contracts. In this lesson, we're going to continue to talk about the distinction that is made between an offer and an invitation to treat, and we're going to do so by reference to some other case examples. So we're going to talk in this lesson about advertisements specifically, and this is something that we touched on very briefly in the last lesson, because we were talking about the case of the Pharmaceutical Society of Great Britain and Boots retailers. And we were talking about the fact that, according to the Pharmaceutical Society of Great Britain, Boots had actually violated the law, the law which states that the sale of a prescription, the sale of drugs, has to be done with the supervision of a pharmacist. And they made the argument that when you have the drugs on the shelves, the taking of the drugs off the shelves represents an offer, and or at least the display of them represents an offer, and the taking them off the shelves and put them into the basket represents an acceptance of the offer. And we got into some of the delineations and descriptions that are made between what is actually essentially an offer to contract and an offer which may have with it and contain with it certain legal binding obligations, and simply an invitation to treat. An invitation to treat, as we remember, is this idea of an offer to negotiate further rather than an offer to actually enter into contractual legal obligations. So this lesson is going to continue this inquiry and continue this examination, looking at a couple of other instances where we find that this is a difficult thing to clearly distinguish and something that we need to think about in more detail. So one of the things that is quite interesting is if we accept the logic and the rationale behind the case of the Pharmaceutical Society and Boots, then what about things where we're talking about shop window displays? From the previous lesson, we know that having goods on the shelves in shops is not a contract or an offer to contract, but rather an invitation to treat instead. But what about the case of shop windows, something being displayed in the window of a shop, even with the price tag attached? Does that constitute an offer? Well, the 1961 case of Fisher and Bell examines this issue. Essentially, the facts of this case are actually quite similar to the facts of the Pharmaceutical Society in a way. You have a defendant who had placed in the window of his shop some flick knives for sale, and they had the price attached. Now, it was argued that this act itself, in doing so, was a contravention of the 1950 1959 legislation, the Restriction of Offensive Weapons Act, because in that piece of legislation they made it a criminal offence, or they made it illegal for the offering for sale, in quotes, of flick knives in a shop window. So ultimately, if the offering of the flick knives for sale was actually an offer, was actually offering for sale by placing them in the shop window, even with the price tags attached, then this represents, as you would probably imagine, a violation of the Restriction of Offensive Weapons Act 1959. So really the case hinges, again, just like with Pharmaceutical Society, the case hinges on this idea of whether or not the placing of the items in a certain way represents an offer or represents an invitation to treat. If it is an offer, then it is offering for sale, and it is therefore a violation of the Restriction of Offensive Weapons Act. If it's simply an invitation to treat, then it is not a violation of the legislation. The courts applied the general rule in Boots, arguing that the defendant cannot be charged with offering for sale, since the mere display of the knives in the window represented an invitation to treat and didn't represent an offer. Now, if we were to accept the logic of Boots, which generally most people tend to do, then there are potentially a couple of criticisms that you can levy at the case of Boots, or at least the reasoning in the case of Boots. But if we were to accept that, then you could probably understand why it is not very controversial that shop windows make no difference to whether or not they're on the shelves or if they're in a shop window. Therefore, the case of Fisher and Bell will follow the same rationale that was established by the case of Boots and Pharmaceutical Society. So that's the case of shop windows. What about advertisements? What about an advertisement maybe in a newspaper or an advertisement online, for example? Can they be representative of offers or invitations to treat? Well, following the rule of Boots and Bell, the general rule for advertisements is that they are not offers, but they are invitations to treats. That is the general rule. One example here is the case of 1968 of Partridge and Crittenden, and this essentially tells us that we have, again, an advertisement and that it is representative of an invitation to treat, not an offer. Similar line of logic in this case as the previous cases. You can see a sort of thread that follows these three cases, because it is essentially the defendant is doing something which is said to be a violation of the law, and the violation of the law involves the offering for sale of a particular item that is prohibited, or maybe in a certain way which is prohibited, like in the case of Boots. But then the question hinges on whether or not it actually was an offer or whether it was an invitation to treat, and that's where the debate really lies. In this case, the defendant had placed an advertisement which read as follows. They said Bramble-Finch cocks, Bramble-Finch hens, 25 cents each. And ultimately, the defendant was then charged in a private prosecution, which was brought by the RSPCA, by essentially unlawfully, quote, offering for sale a bird which was in contravention of the Protection of Birds Act of 1954. As you can understand, this is very similar to the case of Fisher and Bell. We have an offering for sale of a prohibited item, essentially, something which was a contravention of the legislation. Well, it was held in this case that, similar to the case of Fisher and Bell and similar to the case of Pharmaceutical Society and Boots, it was not liable. The defendant was not liable under the Act, since they were not offering anything for sale. Merely, the advertisement which was placed was an invitation to treat. It was an invitation to negotiate, or an invitation to potentially enter into an offer, in which an offer would be made post haste. In contrast to this, what about the case of Carlisle and Carbolic Smoke Ball? This is probably another one of those very, very famous cases, similar to the tort case of Donoghue and Stevenson. At least in my mind, I sort of have them as up there as sort of top 10 most famous cases ever. This is a case from 1893, so it's significantly earlier than the previous cases that we've been looking at. The facts in this case are quite interesting because we see something of a change, a distinction that is made here. Because the facts of this case are as follows. The defendants in this case will place were a company which sold carbolic smoke balls. Bear in mind, as a sort of side note, okay, I've been studying and teaching law for many years. It's only very recently that I actually worked out what carbolic smoke balls even were when I asked a colleague of mine what they actually were. But ultimately, they had sold these carbolic smoke balls, and they had made an advertisement in the newspaper about it. The advertisement stated that if an individual uses these smoke balls 3 times a day for 2 weeks, and they still had contracted influenza, colds, or associated diseases, they would be paid £100. The aim here and the point of this is that the use of carbolic smoke balls is supposed to help alleviate things such as influenza, colds, and other kinds of associated diseases. And they were putting a boast out, essentially. They were saying, if you use our item, if you use our product for the specified amount of time and in the specified duration, and you still contract influenza, then we will pay you £100. We are so confident in our advertisement that you will not contract influenza, cold, or associated diseases, etc., etc., etc. The claimant, Mrs. Carlyle, had done so and had used the smoke balls in the ways which were stated, but had still contracted influenza, and so, as a result, went to the Carbolic Smoke Ball Corporation and decided to say, hey, I want my £100, I want my money. You made this bet, essentially, with us, and we want paying for it. Now, the argument that was presented by Carbolic Smoke Ball was, well, no, this wasn't actually a contract. This wasn't an offer. It was merely a puff piece. It was merely a piece of hyperbolic advertisements, okay? And so, while it may seem that it was simply an invitation to treat, the court in fact held that it was a contract. Specifically, it was a unilateral contract. So, a unilateral contract essentially requires an offer being made to the public and then the acceptance of that offer being done through a specific performance. So rather than a bilateral contract where you have two parties, parties A and parties B, entering into negotiations where an offer is made by one side, accepted by the other side, and we have terms stated, and we have consideration, we have intention to create legal relations, etc., etc., etc. A unilateral contract is where one side makes an offer, and they make an offer a general offer, and the acceptance of that offer is satisfied by the performance of the requirements. Another example is if I was to lose a pet, and I was to go and put lost pets, lost cat signs up, and I've said £100 for anybody who goes and finds my cat. That could be representative of a unilateral contract, because what is being done here is I'm making an offer out to whoever is the person who performs what I want them to do, go and find my cat, at which point acceptance is established. So that is essentially the line of argumentation that was taken in this case, because it was considered to be an offer on pending on the performance of the specific thing, i.e. the use of the smoke balls for a specific amount of time and the still contracting of influenza. The defendants tried to argue that there was not a lack of, there was not the presence of contractual intent. So they said that, well, okay, this may look like a unilateral contract, it may look like an offer, but there was no intent to contract, therefore it can't be an offer. But this was rebutted by the fact that it was actually shown that they had put £100 into a bank deposit, and essentially having that as collateral in case this actually happened, showing that they were very, very much intent and very, very, very much aware of the fact that they could have actually paid this money out, and so ensured that they had that £100 in a deposit, making sure that it was almost as further collateral to the fact that they were very serious about making this claim. And so as a result of which, that sort of debunked the lack of contractual intent requirement that existed in this case as well. It's a very interesting case. It's a very interesting one that you will all examine. But for now, what we will do is start to move on and looking at the other side of the agreement equation, if you will, looking at the acceptance of an offer. And there's a lot more that we're going to have to unpack when we talk about acceptance, because we have to think about different rules for acceptance, as well as the ways in which counteroffers can be made and negotiations take place within the establishment of a contract.